the right button. Just heard myself hang up. Is anyone up there? In Carson City? Can you hear me? Hello?
Can you hear me now? Hello?
Hello? Stephanie?
Yes,
You can hear me?
I can.
Okay, good. I guess we're all set then. Everybody's taking their seats.
When you were talking just now, is that just up to Carson City?
Where else would we go
Or
to?
somebody on, like out in the public on the...
Are you guys ready up there?
Go ahead and start at any time.
Okay. I think the girl that was in here before said if you just press the mic to talk and then unpress it to when you're done.
Buddy. Right here.
You want me to leave this on? It's on.
case somebody's down there.
Oh, and on the record.
We're not on the record, but I think in
Oh, we're not
Carson.
recording this?
I don't know, are we recording, Nova? They are?
Well, the whole thing is being recorded because we're live on the process, so the system has,
And people can log in on the internet.
there's staff down there. The same thing we were doing last.
Minutes. Okay, so we're going to go ahead and start this meeting. It's now 1:10. This is the noticed public meeting for Child Support Guidelines Committee for September 8th, 2017. And I need to take roll call as our first point of order. Let me get my list out. Please advise if you are present as I call your name. Kathleen Baker. Karen Cliff.
Present.
Ellen, and Ellen, how do you pronounce your last name?
Crescelius. Present.
Ellen Crescelius, okay. Senator Farley. Assemblyman Fumo. Here. Judge Hoskin. Here. Nova Murray.
Present.
Assemblyman Pickard.
Here.
Judge Robb.
Present.
Senator Roberson. Joseph Sanford.
Here.
Judge Shirley.
Present.
Justice Stiglich. Myself, Kim Surratt. And Don Thorne.
Here.
Okay. So we have a quorum. And as was stated at the beginning, they're having problems with the mics, so you need to make sure you turn your mics on and off. I think there was a little bit of concern about more than one mic being on at a time. Everything is being recorded. It's 2 down in up in Carson City. Used to saying down in Vegas. And 3 people are able to participate and watch via the internet also and log in. So it's important to use your mics today. We will now move on to the second item on the agenda, which is public comment. We'll start with Carson City. Do we have anyone in Carson City that would like to give public comment? Seeing no one present in Carson City for public comment, do we have anybody in Las Vegas that would like to give public comment? Seeing nobody, we will move on to the next agenda item, which is agenda item number 3, which is approval of the meeting minutes from August 10th, 2017.
Move to approve.
Okay, motion
Second.
made, second made. All in favor?
Aye.
Aye.
Anyone opposed? Motion passes. Move on to the next agenda item, number 4, which is determine committee goals and objectives, which is a big part of why we're here today. That's a gigantic agenda item. It's more daunting than one would think. With that, do we have anybody that wants to start with some comments about our goals and objectives?
Thank you, Madam Chair. I'll just state that the purpose of AB 278 in the first place was to do hopefully more than just effectuate a review of the guidelines, but to actually simplify and make them apply in more instances than they currently do. My hope is that we all have the same idea in mind, that we're going to try to make these simple. In reviewing the materials that were passed out last time, I think we've all had a chance to look at the Montana, I forget what they called that, the name of the review, but ultimately it results in having to hire an expert in order to calculate child support up there, and many of the courts, I'm told, are reluctant to accept the work of an attorney unless they have significant experience calculating child support. So I'm hoping we don't go to that extreme, but instead have an end in mind that is something that each of our practitioners can actually calculate and end up with an accurate answer, and we don't have to go to the likes of those that run our quadros currently But in fact, we actually can do it ourselves. So that's ultimately part of my goals in this, to come up with a set of calculations that make sense, that include everybody, that make it fair for everybody, but at the same time are simple enough that we can actually do the calculations.
I'll go ahead and add to what Assemblyman Pickard said and say that I do think that the recommendations set forth in the guideline review, which if you turn to page 84 of the guideline review, there's an Exhibit 44. It sets out 16 different recommendations. The first of which I believe we can ignore as one of our goals and objectives, because it was to essentially form this commission, which has happened through the legislative process, and we've already accomplished that goal. So I would ignore number 1 of those recommendations and probably replace number 1 with the fact that we need to also look through our current statute, the statutes that we're going to be replacing with our review and our recommendations, and determine what of those statutes need to continue to exist, meaning the good parts that we have that we're not getting rid of, that we're going to maintain, before we can move on to the parts we're going to change of our child support statutes, and make that number 1. And perhaps, I don't know if the best way to approach this today as a group is to go through each of these and make sure it's something we do want to make a objective and goal of this commission or not, or if anybody has any input on that. Feel free to speak up.
I just wanted to add, with Jane Venor's report and the 16 recommendations, I would agree that all 16 need to be addressed. And further, I think one of the big ones is whether Nevada is going to continue to use the percentage model.
Can you guys hear us in Carson?
Las Vegas, can you hear us? Please, somebody press a mic and say, talk back, please. Please. Las Vegas, can you hear us? Can you hear us, Las Vegas? Please, please, pretty please. Somebody? Mic check, 1, 2, 1, 2. Test, 1, 2. Hello? Test, 1, 2, 1, 2. Mic check, 1, 2, 1, 2. Test, 1, 2, and 2. Test, 1, 2. Test, 1, 2. Okay. Mic check, 1, 2, 1, 2. Vegas, can you hear me? Vegas, hello, Vegas. Nope, they are not responding. They can't hear us. They cannot hear us. Got it? Okay. Test, 1, 2, 1, 2. Mic check, 1, 2. Test, 1, 2, 1, 2. Test, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2. Test 1 2 1 2 1 2. Test 1 2. Test 1 2 1 2 1 2. Test 1 2. Test 1 2 1 2. Mic check 1 2 1 2. Test 1 2 1 2 1 2. Test 1 2 1 2 1 2. Test 1 2 1 2 1 2. Mic check 1 2. Test 1 2. Hello.
It's working.
Oh, we can hear you. Can you hear us?
Oh, yay! Yes. All right. Blah, blah, blah. Yes, Ms. Cliff was in the middle of a statement, and I wanted to put on the record that Senator Roberson has appeared again. And, Ms. Cliff, if you want to finish your statement. Oh, yes. I'm sorry, Senator Farley's also here. Yes, I forgot you weren't here at the very beginning. I will mark you on my notes, too.
Karen Cliff from the Clark County District Attorney's Office, trying to recall what I said earlier. Just in support of Jane Venor's recommendations, her 16 recommendations, I would like to state that I prefer to focus on those as well as some of the other issues. She brings forth some really interesting points. Some of her recommendations regarding health insurance and deviations and Nevada's presumptive max, health insurance costs, child care. While all of those are recommendations that absolutely need to be addressed, in terms of prioritizing some of her recommendations, I would like us to address how Nevada wants to see our child support model moving forward. That was one of the recommendations in her report. Of course, Nevada is one of 3 that currently use the percentage model, looking at respondents' gross monthly income or obligors' gross monthly income. Whether or not Nevada is moving forward to keep that model or looking at perhaps a shared income model. My recommendation would just be in terms of prioritizing to sort of look at that before we start considering all of the other recommendations that she has insofar as the presumptive max, health insurance costs, deviations, et cetera. That's it.
Madam Chairman? This is Bridget Robb. I would like us also to, if we can, keep in mind a goal of ensuring that whatever we do, that child support enforcement will be uniform across the state, and that the enforcement isn't going to be dependent upon the judicial officer in front of whom the order is being argued. I think we need to be careful that enforcement can be done and can be done uniformly across the state.
Do we have additional comments about our goals and objectives? So to summarize, and whether or not, we do need to kind of finalize, because our next agenda item will be determine process to set up future meeting dates. So under this agenda item, I think we really have to concrete whether or not we're going to work off of Exhibit 44 or not, the recommendations from the guideline review, and make an official call on that as being part of our outline for goals and objectives. What I heard was use Exhibit 44 recommendations, the 16 recommendations as our format to move forward with my statement was to replace number 1 because we already have users and stakeholders. This commission is the number 1 recommendation, and to replace it with reviewing our current statutes for what's going to be maintained. And I heard to change the priority level of Exhibit 44 to move the which number is it? Is it number 5, Ms. Cliff, that your statement was to eliminate the presumptive maximum amounts, move that in priority up?
No, it's kind of interesting, but on page 83 of her report where she delves into the conclusion and recommendations, and just as, sorry, Clark County, Karen Cliff from Clark County DA's office, to the left of Exhibit 44 is where she goes into some of the various child support models briefly. She talks more about it in depth in her report. But going over to her recommendations, I'm not sure if she just sort of incorporates it. I'm not sure if she means to discuss it as item number 2, the premise and basis of the Nevada Child Support Guidelines model. She says review the premise and basis of the Nevada Child Support Guidelines, and in her report, early in the report is when she discusses some of the different states and how Nevada's distinguished in the consideration of an obligor's gross monthly income. I'm not sure if it's just sort of an umbrella topic and the rest sort of fall under it. But in terms of the 1 through 16, I don't specifically see it.
As Kim Surratt, for the record, I'm looking through them real quick because I feel like it was in those 16, but
Yeah.
kind of spread out in concept, I think.
I agree with you. She addresses it in bullet point 5, that's at the top of page 84, where she states there are concerns with Nevada's guidelines. We're in the minority of states that do not consider both parties' incomes. But I agree, I think it's woven throughout her recommendations.
Again, Kim Surratt, for the record. I think that somewhere within these 16 also there was a specific statement about assessing the income of both parties. So really what we're talking about is, are we going to move to a shared income model away from what we currently have?
Yeah, it's some of her considerations in terms of, you know, some of the problematic issues Nevada has, for example, deviations, which goes towards the earlier comment that before different hearing masters or before different judges, we may find ourselves having different decisions. Part of that is the deviations because we don't have any set standards. My concern is that when we start addressing health insurance and deviations, we may feel differently if we were to use an income share model versus a percentage model. So I sort of view a lot of her concerns under the umbrella of what model are we going to move forward with as a state, whether it's keeping it as is or going with some of her analysis on some of the different states. Quite frankly, I don't know if I could be specific about some of her recommendations in terms of what I would like to see if I'm not really sure the framework that we're going to be utilizing moving forward.
This is Joe Sanford for the record. It appears like that is under Section 3, determining the base guidelines percentage and formula. And I would put my support that that is, I think, the top priority in determining, before we address what deviations should be applied and how much those deviations should be, the determination of the base amount and the formula that's going to be used for determining that base amount is the first consideration.
Just Charles Huskin for the record. While I'm not opposed to the 16 recommendations, I just want to sort of voice a concern that the entire guideline seems to be heavily focused on the child support enforcement program and sort of leaving out what we do outside of child support enforcement, but still dealing with child support. So just as an example, we're presuming in the report that we know what is a custodian and what's a non-custodian, and I think that probably needs to be defined either more specifically or to simply accept the Supreme Court's definition. But I think that that's going to have some changes. There's some reference to Wright versus Osborne in here, but I think it's important that we, I don't know, I guess my concern is that we're limiting ourselves to the 16 guidelines if that's the, or 16 factors if that's what we're doing. But I think there's more that needs to be considered when you're considering child support across the board and not just the enforcement portion of it.
Keith Pickard for the record. Before we came forward with AB 278, one of the things that I heard from a few people was the idea of eliminating the distinction between primary physical custody and joint physical custody and just go with a parenting time arrangement from the start. And that led to a discussion with respect to child support. And that under the current scheme, we've got this dichotomy where people will often ask for joint physical custody, not because they want the time, but because they want to have to pay less money. And I think if we were to go with the shared income approach and decouple it from the parenting time altogether, we could actually move to the idea where we don't have to then worry about a distinction between primary physical custody and joint physical custody, and we eliminate a lot of the unnecessary fighting. Now, I know that's beyond the scope of what we're meeting about, but I think that they dovetail quite nicely, particularly if we look at something like the way, and Ms. Throne and I were talking earlier about the Utah approach, where they look at parenting time, they look at the combined income, and then it's paid on a pro-rata share. It simplifies things, and it eliminates a lot of the fighting and in both directions. And so in my mind, that's kind of where I was hoping that this would go, to a shared income model where we are cognizant of but not necessarily dependent upon the parenting time that's associated with the underlying custody award, and then make it something that we can easily calculate or relatively easily calculate and move the cases through. And I think that would also assist the child support enforcement arm because then they would have the same simplified system, and my guess is if we can lower the temperature of the fighting, then they would see fewer cases outside of those where someone just decides not to pay.
I'm not prepared today to weigh in on which model would be the best for our program. There's, of course, the percentage model that Nevada currently uses. There's also multiple types of percentage models. There's net income and gross. Nevada, of course, relies on the gross income. There's shared income models. As David Castanel pointed out earlier at the prior meeting, the Melson formula, which is a hybrid formula. So I'm not prepared today to discuss which model would be the most suitable for Nevada or the program. I can say the percentage model is perhaps the most easiest for our program because we don't often have the income of the other party. And oftentimes only one of our parties is working, and it's the custodial parent, which could result in the custodial parent paying the non-custodial parent. So there are some complications, and I would, of course, need more time to provide any sort of input on which model would be best for us.
Dawn Throne. And that's where the difference between child support enforcement cases and private practice cases come in, because most of our private practice cases, the standard operating procedure is shared custody. So we are using a shared income approach under Wright v. Osborne, and both parents' incomes are considered. I don't know if it comes to the right result, but it is a shared custody as the preference in our state. We have to recognize that these guidelines were done 30 years ago when that wasn't the case.
Any other comments? So the goal of this agenda item was to determine committee goals and objectives. And I think I would summarize it again like we just talked about. I think number 2, if it satisfies Ms. Cliff, I think number 2 is where we can talk about this big concept. And I do agree that we need to overcome that hurdle of whether or not we're doing an income share model, if we are sticking to percentages, where we're going in that big picture. In setting our goals and objectives, obviously, one, this is going to dictate some of what our schedule is and how we're going to set our agendas and which topics we're going to deal with. But also, as I think we also will be developing with that in looking at our goals and objectives, what kind of outside information we're going to be wanting, presenters or information, which states we're going to be looking at as models, or how we're going to get that research, how we get it into this meeting. For me, as somebody who is new to these type of public meetings, I want to, as a committee, to speak about how we're going to get that information for ourselves. And how we're going to look at that, whether it's guest speakers or how does that work? What do we do to accomplish that goal? and that objective. Any other statements, comments? Do we want to make a motion on using these recommendations with any of these comments that have been made?
This is Joe Sanford for the record. I would make a motion to use the 16 recommendations as an initial goal and objectives for the committee, with the understanding that should additional topics come to mind, that we can add to them.
I'll second that.
Okay, we had a second from Assemblyman Pickard. All in favor?
Aye.
Aye.
Anybody opposed? Okay, motion passes. In determining our goals and objectives, so we're going to use this as a framework, this being Exhibit 44 of the Guideline Review, which is on page 84. That was what we just voted on. With our, I would say, in determining our goals and objectives, we should be looking forward to the very next meeting and what the goal and objective is of the very next meeting, so that we can properly set an agenda and have enough information. Some of the input I heard was perhaps we start with, well, there was some input about starting with number 2 of the recommendations versus number 3 of the recommendations. Do we have any comments or input on that? Thoughts? Mrs.
Nova Murray for the record. I'm not sure how to even start a process like this. This undertaking is huge. Generally, when I walk into things that look like this, I go look at the other wheels on the market. So I would go out to the successful states that perform well in their area, which would mean they aren't deviating from their child support much. So a lot of consistency. They're ranking high in collection and other types of things that they're measured on, and possibly bringing back what they look like, what their state looks like, what their structure looks like, if they're similar to us, and then maybe bringing that data here somehow, having people go out, grab it, and bring it to us so that we can look at successful things and see if maybe there's a model that we tweak to meet our needs, or things that are different about us that we could tweak, so that we aren't sitting here rolling around about things. I could debate all day long on 5 different sides of this coin, which way to go, depending on what somebody presented. But if we really had tangible information from other states, successful states, I would say stay toward the top and just look at the way they did it, what they considered, what their state looks like, and maybe it gives us a really good place to start. For the record, this is Nova again. That's how I build programs. I've been in program for 26 years. I go out and I look at models of other states, how they perform, what they accomplish, how it matches what our state wants to accomplish, and I shop. And sometimes when I'm doing that, I take 3 different ones and I bring the pieces I like about each one of them, and sometimes one looks like it works for me really well. So just an idea.
Charles Hoskin. As I read through the materials, I took notes, and of course I left those on my desk, so I don't have them. I'm going by memory now. But I kept coming back to, is it broke? And I've posed that with what we have now. And in reviewing this, I didn't get the feeling that she thought it was broke. She put us sort of in between, and that some tweaks need to be made. So I think that it would be helpful, and I think it would be helpful today, if we can decide, one, is it broke? And if the answer is yes, then I think we start looking, okay, who else is doing it better? Or we decide, you know what, it's not broke, but it needs something, then I think that's a way to kind of approach it and move forward. But from what I'm hearing, Nova, from what you said, I feel like she's done that in here, at least compared to other states. I know, and it's got a bent on it that I'm not happy with either, but I think that preliminary groundwork has been done. So if we could have a discussion on whether we think that at least the premise, we're not alone, well, we're in the minority, but we're not alone in the way that we approach it. But I think we start with that, and we can probably build on that and maybe accomplish some things so that we're in a better position next time would be my suggestion.
I would like to second that strongly.
This is Bridget Robb for the record. In looking at is it broke, one of the things that was strongly in the materials is the amount of deviations. And I quibble with that. In fact, I object to that because deviation, one of the things that I know Judge Hoskin and I do and Judge Shirley routinely is we divide up the insurance premium. That is technically a deviation, which is one of the reasons why the deviations are so high. If we build in a way to just divide up the insurance as part of the formula, and it's not a deviation anymore, we bring that deviation number way down, and that's one of the problems that was identified in this report. That's an easy fix. I am very concerned about going to strictly looking at the income of both households because that becomes more subjective than objective. And that gets us to it matters which judicial officer you're in front of, how they look at the income numbers and what that means to them. And I'm also very concerned because I've actually seen this result in appeals that have come up from child support officers where the non-custodial parent is the one who is actually getting the child support. That's nonsensical, and we cannot have a result from this committee that leads to that kind of inequity. Thank you, Judge. Sure.
It's Senator Farley for the record. Just a quick question. So my understanding, not a lawyer, not a judge, but I am a recipient of support, and I'm also a primary parent. My understanding is that there's a maximum, though, on the percentages. So you may take somebody who is one parent makes quite a bit more than the primary custodial parent, and they max out. And then you put parents who are maybe similar to me, who's the primary parent, at the dependency of the court to try to collect on anything else that that child may need from the parent who clearly won by the, and I'll be honest, I think it's a low amount, which is our state maximum, when raising children. So I wonder if that's a huge break there as well.
It's one of the reasons why we were very careful about making sure we included private family law attorneys on this commission, because the analysis with our cases versus the 4D cases is very, very different. I think we are broken when it comes to the high-income cases. We had examples when we were working on getting us to this point of having this commission of, a father who had a child that was under the jurisdiction of California for child support and one that was under the jurisdiction of Nevada for child support. The child in California jurisdiction was receiving $16,000 a month in child support, which can sound astronomical, but the child in Nevada was receiving the maximum $1,400. And so you've got one child that can afford to go to private school, amazing extracurricular activities, and their half-sibling doesn't get to do any of those things. Not that we need to match California or match other states, but one of the things very clear in this report is with our maxing out where it becomes your income's at $14,000 and limitless after that, our percentages are really askew with our presumptive, those cap amounts, where the lower income parties are paying closer to 16% of their income in child support, and the highest income earners are only paying 7 and 8% of their income. And so those gaps are part of what we need to address. The problem with in answering the question of, is it broke? This review, and we knew it was a problem when the review was being done, we had no ability to give private case data and statistics for the review to be done off of. The 4D cases are easily traced through the software that they utilize. Private lawyers, one of the things that we have to deal with within this commission for future guideline reviews is how do we get that data from private cases? They looked at, the handful of private lawyers that were participating in the process. We didn't have a methodology to do it. I mean, unless I sat down and literally opened each case in my computer system and sat there and wrote down what the income levels were for each court order to figure, there was no methodology behind it. So when answering, are we broke? We may be, because the private lawyers were sitting there going, it is broken with a lot of our examples. We can give a broken example after a broken example and at one point, the statement was made that our numbers seemed to come out okay, but it's like by hook or crook they came out accidentally okay. Not that the right analysis was being applied every time or that it was consistent enough. It's just that once they averaged it out, it seemed okay. And to me, okay is broken. That's not sufficient. And obviously where we're broken, though, is within these recommendations has very specific things about where we're broken, which, as Judge Robb pointed out, some are very easy fixes that will dramatically change a lot of outcomes. Her example was the medical insurance, and another example is the $100 minimum per child per month. When you're under the poverty level, that's a dramatic percentage of your income and an inability to pay it. But we have that is a hard set number within our system, but easy fix that when we meet these deadlines or these goals and objectives and we put them forth, we can actually help satisfy. But there are two different problems there, the two kinds of cases.
Senator Farley, for the record again, is there a state that you guys are aware of that does best on the focus of the best interest of the child? Because I think in a divorce, we lose focus of what's the best interest of the child. So if the child was in dance previously and attending a private school and doing all this other stuff, and just because the parents make a choice to split, and I understand there's two incomes, two homes and costs there, but it never seemed like it ever got back to what's in the best interest of the child. And then holding parents responsible for continuing that based on maybe income and not so much just here's a percentage. If it works, great. If it doesn't, somebody's going to make up the difference. And normally that's the primary custodial parent.
I can't answer on this, Kim Surratt, for the record. I can say that in reading all of the materials, I feel like that was one of the things in trying to decide what our goals and objectives are, that I looked at this and went, this is where you have to grasp that difference between what the feds want of us and balancing it with our state policy. Because the federal government obviously is looking more at ability to pay and at the parents and their incomes and those circumstances. And the child is way down the list. When you read Nevada's statutes, it's the best interest, the child's, at least it's written that way. I can tell you in practice it's not necessarily that way. But in the way our statutes are written, they appear child-centric. But they're part of the reason that fluff, that discretion, is what's causing some of our problems with the numbers working out.
This is Judge Robb, and I believe that one of the distinctions and why the federal policy is different than our state policy is federal policy is really aimed at we are going to keep people off of public assistance. And so we're trying to find ways in the child support system to do that. The state system is entirely different. And the question that you asked about best interest of the child, that is so amorphous that you wouldn't be able to study it state to state, unfortunately, because it is a case-by-case analysis. And to a certain extent, we need to build in some flexibility for case-by-case analysis, But I really object to building in the type of flexibility I think you're asking for, where it is by child, because then we get to places where a child who lives in Clark County is going to be treated differently than a child in Elko, and we can't do that. We have to have a system that will be fair to all of the kids in the state.
Keith Pickard for the record, and if I can just add to that, I agree with what Judge Robb just said. With respect to your example, the fact of the matter is facts change. So when a couple is together, they're working together, they make decisions together, and they set up something for their child, and then something goes wrong with the relationship and other choices are made, sometimes other choices with respect to the kids have to change. The practical reality is one that if a couple is paying for private school, for example, and then because of the divorce, one party or both can't afford it, is it really in the best interest of the child to continue? Well, probably not if it means somebody's going bankrupt. So, you know, I agree, these concepts are amorphous in that they change and they're hard to identify in a way that we could reduce down into the statute, or in this case, the regulations with respect to child support. But I do think that we probably ought to have a willingness to keep our minds somewhat open. For example, Judge Robb says, you know, we should never have an instance where the custodial parent is paying a non-custodial parent. And I can immediately bring to mind some situations where that might actually be appropriate. Even though they may have the bulk of the time, the other parent may need some assistance in order to provide some of the things that are deemed to be in the best interest of the child, particularly if we have, say, special needs or something. But I mean, and I'm not trying to be disagreeable here. I'm just pointing out that I think we need to approach this with a pretty open mind and consider. I do like the idea of considering multiple states. I'm familiar with Utah because I practice in southern Utah as well. And so I'm comfortable with that. I like it better than Nevada, but is Utah better than Oregon or Arizona? I don't know. I don't practice in those states. But I would like to make sure that what we do is exactly to your point, Senator Farley, and that we're keeping the kids' interests in mind, and we are making it uniform throughout the state.
Judge Hoskin again. I think getting to the point that was raised, and it may be something simple, I've only practiced in Nevada. So I was, a year or so ago when we were looking at this, I was shocked to learn that Nevada is the only one that has a maximum. I assumed everybody had a maximum. So I think that's probably in the realm of stuff we could probably fairly quickly say, all right, we're going to do something different with a maximum so that we eliminate that difference. You know, if we're one of three, okay, well, maybe we're smart. If we're one of one out of 50, then maybe we need to take another look at it, would be my analysis. So I think the issue you raise is an easier fix than the philosophical, is the income approach appropriate?
Keith Pickard for the record, if I could just respond. One of the things that they mention here is the fact that not only are we the only state that has a maximum, but that the states that don't have a maximum are actually counterintuitive when we look at economic theory, and the fact that families that make a lot more money tend to spend less of their income on the children. It becomes more of the disposable income, the luxuries, that sort of thing. And so if we eliminate a cap, we then should probably figure out a way to reduce the total support as it goes up. We don't want that $19,000 or $16,000 California award that is fixed and it continues on forever, because that's not really the purpose of child support. As I understand it, the purpose of child support is to make sure that the reasonable and necessary expenses for rearing that child is met, in tension with the idea that they would maintain the status or the standard of living that they had during the marriage. So all these things are in tension, and in the discussion we need to figure out how we don't make it unfair, because we don't want a disincentive to making a lot of money. ultimately, that helps the child, so we don't want to make it a punitive thing either.
Senator Farley again. So I just want to bring up this point. So I said, if we go back to being child-centric and two people, so in the private sector, my guess is this happens more than often than not, that the couples settle and they start discussing, hey, we're going to do this, we're going to do that. And then what happens is the one parent or both parents begin to realize, hey, I'm only on the hook here for $1,000 or $1,400 a month. So then the negotiation, the best interest of the child stops. And so that's where I'm saying I don't think that, granted, if one parent can afford private school and the other one can't, you can't make the other one pay. I mean, that's just a simple discussion of math. But I do wonder if there's a model that says if you start out in the child's best interest and you look at incomes, can you not disincentivize one parent from meeting that child's needs or continuing to offer what you would have had the union stayed together, and that child still go on to be able to participate and live. And you talked up front about the amount of divisiveness between people and how some of this process continues to make that grow. Well, when it becomes lopsided for one parent over the other, then you still have that animosity growing and growing. And so that's why I'm wondering if in the process of splitting up, if the lawyers and the judge were really about, okay, well, let's talk about how your children live. Let's talk about their needs. Let's talk about what each person can do while also having, a wholeness of their family and their life and being able to go forward. And I'm wondering if there's a state that has a model that we've just seen some really productive family law come out of, and productive families enter maybe broken families entering the divorce system and then come out as productive co-parents afterwards, because I think that's where we all probably want to get to.
Just kind of a reminder, looking at Venor's report, it appears about 39 states go to that shared income model. Now, in what form they take, I don't know. But if you go to that shared income model, of course, you're at that point, you are looking at the custodial parent's income, what comes into her household, any assets, income, et cetera. I think there's only about 3 states that go to that sort of hybrid system. So in looking at best interests of the child, of course, changing the model would, of course, change many, many things. Wanted to throw that out there. Thanks.
All right, I feel like I'm on the hook.
Madam Chair.
Kim Surratt, for the record. All right, I think we're getting on track. Actually, this is what I hope we get out of this meeting, so that we were all in one room together, because it was really hard on the teleconference. But this is the in-depth conversation that we're hoping for out of this commission. So I think the next step or the next question is, what do we need for the next meeting to set that as our agenda item and know we can really dive into it, to know, are we going to go down that shared income avenue? Are we going to stay at percentages or not? Do we need, we talked about collecting from the top states, the information, bringing it back, doing our homework in between. How do we get there? What do we want to do to get there? And I'm assuming at this point, are we starting to develop consensus that the next meeting really should be that topic before we move on to all the others? I feel like that's what I've heard.
I think that's a good idea. This is Joe Sanford for the record. In preparation for today's meeting, I had a staff member prepare a sort of comparison based off of one of the exhibits in the report, specifically Exhibit 22, 23, 24, and 25 on page 36 and page 37. That is the comparisons of Nevada child support formula using the median earnings for males and females with different levels of education, and kind of running that report through some specific case scenarios. I brought copies for, I think, everybody who's here. So I was trying to pass those out to everybody. There's 2 pages each, so
Or I'll do that, you speak.
And I don't want to vouch for all of the numbers here because I didn't personally calculate them. They were all run through. There's 2 pages each one. I didn't personally run through all of the numbers using their exact basis. I used their state-provided child support calculator. But I was hoping that this would be a starting point for the type of information that I would want to see collected and reviewed by this commission in determining whether a income shares model is preferred, whether our current model is preferred, and basically starting with looking at these numbers as case scenarios for, does this number that comes out make sense to me? Is it fair to all parties? Does it provide enough support for the child is probably the first goal. And then second is it fair to all of the parties? Third possibly being, from my view at least, is it simple and easy to calculate and understand by the parties so that if I'm at a hearing and the father is there without representation and the mother's there without representation and we're going through these numbers, that they're going to understand why we're using these numbers and where these numbers are coming from and how we got to the end result. And I know there's a lot more scenarios that are available that could be done out there, and specifically I think a low income and a high income scenario definitely have to be in there. The numbers I used were the median numbers, which were even for less than a high school degree, 19,427 for females and 25,794 for males, substantially above the poverty level. And the high level for graduate and professional degrees was 51,667 for females, 66,334 for males, and that is substantially lower than the truly high-income examples that I think are considered by our presumptive maximums and the problems that are coming from there. And so I just wanted to have this sort of as an example for if someone has staff that can actually create this type of information, not just for, I used the local states that were already sort of provided in this report of California, Idaho, Arizona, Oregon, and Utah, as well as Nevada, but perhaps the other states that use a percentage of the obligor formula, I think was New York and I can't remember, but there was one other state as well, Wisconsin. And so if this could be expanded, I think that that's the type of information that should be a starting point for deciding whose formula is right in the most number of cases, and do we want to start from there instead of trying to reinvent the wheel altogether?
I appreciate the chart. This is Karen Cliff from Clark County DA's office. Just going back to the comment from Judge Hoskin about before we expend too much energy researching and looking at other states, just sort of making that initial determination about whether or not we even want to move forward, changing our model, something other than a percentage model, a percentage gross monthly income model. But also, in addition to looking at stats, looking at the burden on both the 4D and or family bar if we do change. As many of you are aware, the 4D court doesn't get involved in custody determinations. We are not federally funded to do so. So generally when there's a family court order, states Wright v. Osborne, whatever the custodial arrangement, we of course follow it. But as many of you know, in a 4D program, many of our cases lack a child support, a custody order. That would be a great influx of cases. Just wanted to put that out there that since we can't make these determinations, when you move to an income share model where you're talking about various nights and various homes without a court order to that effect, that would put a burden on a 4D court to hear those cases, and they would have to move to the family court bar. So I want to put that out there as it's more than just the numbers. It's also, of course, the various burdens that we may inherit as a result of changing the model. Thank you.
This is Bridget Robert, and for the record, and the other thing I think we need to look at in this chart, and I appreciate all the work that went into producing this because it is useful. We need to remember when establishing child support the information that is available to the court. And many, many times, I don't even have one party's income available to me because they haven't filed the necessary documentation even after I've ordered them to do so. The more we require of information and the deeper we get into things like what's your level of education and those type of things, the harder it is going to be to establish child support. And I think we need to be very, very careful about making that establishment even more difficult.
Judge Hoskin again. And then all I'm really trying to do is keep us kind of so we're not spinning. And after digesting all this, I take a look at the child support formulas and the way that we've gone about it. And when I started practicing law, you couldn't pay more than $500 a month in child support. That was the max that anybody would ever pay, no matter what they made. And we thought it was a great change when they finally made that change. And then looking at it, that we've got other issues that are coming into play. But the child support formula that we have now is simple. It's inconsistent when you talk about the 080 deviation factors. But for the most part, it's not too far off of all the other states that we've been comparing to. So, yeah. And while, like I said, I've got some fundamental disagreements with some of the way that statistics have been used, it meets the criteria. It just hasn't been looked at forever. So if I was going to make a suggestion as far as moving forward, that we start with what we have, we determine what's wrong with it, and we fix what's wrong with it. The deviation factors, there's some concern that the courts are inconsistent, and that's why I use the word inconsistent in an application of the deviation factors, and I would agree that that is the case. I may put more value on one of the deviation factors than Judge Robb or Judge Shirley with the same set of facts, and I think that renders an inconsistent result, but it also allows us individually to look at the facts and circumstances of each case, to look at best interests of the children, and to make that part of that child support order. And the Supreme Court just yells at us for not making enough findings with regard to that, even though that may be what's going on in our head. So getting back to Ms. Cliff and trying to make a determination, and I'm not here to tell you that I think we should do one approach or the other, but I come back to, is it broke? And should we make wholesale changes, or should we take a look and see what's wrong with what we have and see if we can make some tweaks to it to make it better, and going along with that analysis. And as far as the exhibit that was just handed out, I appreciate it, but it doesn't, that of all the stuff that I read, that was not what spoke to me, because it didn't give me any information other than here's a mean and here's what everybody's doing and are you somewhere in that range. I don't think it helps me beyond that. But that's my approach, and I understand that I look at it differently than others, and that's why there's not just judges on this panel, which I appreciate, by the way.
I agree completely. Keith Pickard, for the record. In fact, when I was looking at this and when I was looking at the materials, one of the questions that came to mind was, are we deluding ourselves in thinking that any calculation is going to give us a wildly different result? If we accidentally fell into right down the middle of between the high and the low I wonder if any result that we come up with will end up in that spot. If so, then I'm not sure we need to worry so much about the end results, the numbers, because if that's true, they're going to come into, somewhere within the appropriate range anyway. But maybe we should be focusing more on some of the best interest issues. One of the things that I hear constantly is about that stair step that we have built into our system, where you make $1 more and all of a sudden you're paying $60 more a month in child support, and there's no substantive difference between that dollar, and that creates problems. And for me, and this is just my personal filter on this, is that we spend so much time arguing about child support because it's relevant to custody and vice versa, that one of my goals in wanting to participate in this group was to try to decouple the two, come to a system where no matter what the custodial arrangement is, we can estimate what the child support's going to be. I think that the custodial parent's income is relevant to the equation with respect to the best interests of the children. And so to me, and again, simply because I'm familiar with the Utah program, I like the Utah program better than ours. And so in my mind, I was thinking, well, that's a great way to go. But if there's a better one, great, but let's debate it. I think, to Ms. Murray's point, I think that what we should probably do is identify a few states and maybe even have the author, Ms. Is it Venor, come in and give us a brief presentation on whether or not the states that she looked at were chosen for a particular reason. Were these the most close to what we have today, and so it gives us a relevant point at which to maneuver, or if they were just picked at random? If they were picked at random, then maybe we should spend some time on an analysis of what states are closer to what we have so that we don't have to wholesale change everything. But that would be, I think, an initial point I would like to see, and then maybe get some presentations from experts in these other states' programs. I'm sure we can find practitioners at least that have experience with both Nevada and the other states, so they could come in and talk about the strengths of the other state or the weaknesses of the other states' programs vis-a-vis our own. And then we could get the context, and I think that might give us some sense of direction where we want to take it.
Without, this is Kim Surratt for the record, without going through the report, I do believe she does do some analysis for you about breaking it out by the different kinds of models to kind of group states together. And then she also did one based on our neighboring states so that regionally the report was relevant, because obviously the East Coast and the West Coast have very different experiences with all kinds of things. But she did address why she did certain states and what their relevance was for her analysis within the report. So I think that information and that data is there. And one of the reasons being, one of the variations she did is based on what they consider to be high performers, the states that are the high performers. So again, this is that weird dichotomy between the feds and the way they look at it versus our state perspective on it, which is they want to see us have less deviations, higher collection rates, and they look at that success level being a direct result of if you set an appropriate child support amount on the front end, then you're not chasing the dollars on the back end. And so her comparison and analysis, some of that looked at the states that were successful. So when we look at models, when we talk about looking at models we like, doesn't necessarily mean it's going to be a model the feds like, and that meets that high performance standard on less uncollected child support, which is a great goal. But it also, I mean, I'm like you as a private attorney. I prefer to look at the whole balance of things. I like to look at the best interest, but I 1,000% appreciate Ms. Cliff's comments about in the 4D program to do that same kind of analysis that we're doing on a mass assembly line schedule of assessing child support and moving forward and at least getting it done in computer software and what you went through, Ms. Murray, with the legislature just for your budget and dealing with that bigger perspective on that stuff. We have to appreciate that and understand it before we just wholesale replace our methods.
Nova Murray for the record. If we're going to make it and do it and change it, now is the time. If that new system comes in the next couple years, we are already getting ready to build it. If you want to make dynamic changes, this is it. Once we build a model, if we did go to a shared income model, today's the day. By the time it comes out this back door, it'd be ready to go into that system. We would have to fix other pieces to make it work right. We can look at other states to see how other states get it through their judiciary system. But if we are going to make a big change, we can't wait. That system is costing the state a ton of money, and now's a good time.
If I may, Keith Pickard again for the record. Just to follow up on what you, Madam Chair, mentioned, I think Judge Robb raises a good point, and that is, and I agree that I suspect when we talk about a system that isn't working well, we're actually incorporating, or that assumes some things that I don't think I agree with respect to what constitutes a deviation. I think the number is overstated because I don't think much of what we see on the bench isn't really a deviation. It's the consideration of the other factors. It's consideration of the cost of child care and insurance and these other things. And so I think it may be an issue of semantics. So we may be able to bring it in line with the federal idea just by changing how we approach it. We don't call it a deviation. We call it a consideration. Work it into the formula so that, and it's another input based on real numbers. It would make things, I think, a little easier for the 4D program because now we're no longer we're not calling it a deviation. And with respect to, opening the door to additional litigation, I wonder if we can't do it the way we're doing it now, which is we just look at it as a snapshot in time. We don't worry about trying to change, and certainly we can't put it on the child support enforcement to consider custody at all. They can't do that, nor do I think they should. But it's a snapshot in time. I think we can probably address much of the deviation issues simply by how we consider it and how we label it.
Senator Farley, real quickly, to the Assemblyman, you've talked a couple times about the Utah model, and the thing that you liked about it was it pulled out the custody agreement away from the support. Did I miss? Okay.
Indirectly, yes. It's blind, actually, as to what the custody order is. But they look at, it's a combined income model. They look at the income of the custodial, well, they consider the income of both parents and factor that in. They do consider time as part of the equation, but it's actually a minor part. It's lower in the form that they use. They also, by the way, do that online, and I suspect they do that in order, or they have a calculator online, and I expect they do that in order to capture data. I don't know that for sure. I just know that it's a very effective tool. We go into the courtroom, the judge has it on his screen, we have it on ours, and we do the calculation right there. It's very simple. You come out with a hard number at the end. And in looking at Mr. Sanford's chart here, it's pretty consistent with the final numbers that we end up with.
With our current 4D cases, and I have to be very avid about the fact that the private bar was very adamant about being on this commission for the point of saying we're not getting consistency. The 4D cases, when you have the same hearing master doing nothing but child support cases, one after another with the same DAs, deputy DAs, who are very consistent in their approach, using their software, inputting their numbers, you get consistency. When you look at the private cases and suddenly custody's at dispute and asset distributions in dispute, and you've got and spousal support, and you got different judges with different opinions, and they've decided they like or don't like your client, you get a very different outcome than you will get if they just ran through as a 4D case. And so the inconsistencies of our judges is what it drives the private bar absolutely berserk with these cases. I mean, we really could pull our hair out over it. And it is, and I can tell you that I don't think it's just the private bar. I think it's part of the public conception, too, of the problem when you've got two people who hang out in the same social circles, who are both paying child support, but are paying dramatically different child support numbers, and they really don't have different economic situations. And they talk about, one says, well, my judge hated my guts. Those comments come out, and the only way to get away from that is a nice, solid equation and approach to child support that takes away too much, when they have too much discretion, you get those problems. But then when you don't have discretion, you see it from the bench side of it, which is, but I can't accommodate when I need to accommodate. But which one's better? Letting them accommodate, but their own personal opinion about the litigants comes into perspective. I'm sure judges don't think they do that. And we have very good judges on this commission, but there are judges that do that. Others recuse themselves, yeah. No.
Senator Farley again. So in the private practice, when you're trying to negotiate, right, and you get that one parent that's like, I just hit the limit, Denzo, right? Take me, let's go, right? Well, the other side's strategy is let's get it in front of the judge. Let's let the judge decide. So that discretion keeps the negotiation rolling, and so it's just I don't know how else. That's why I was interested in taking the custody issue out of it. I wonder if that would change the dynamic. But to be honest with you, when you get that one parent and he or she is done, the threat is, okay, let's see what the judge will say. And that normally continues to keep people talking.
And I think the private lawyers on the commission would probably agree with me that we have a significant number of custody disputes that are only a custody dispute because they know it impacts their child support amount. So they're not going to, they would have done what was right for the child on custody, but for winning on the child support a part of it. And that's sad when that is our battles. And it's a huge number of our battles.
Let me give you a different side of that. I have people who most times aren't represented by attorneys who will mediate a custody resolution, and they'll come before me to ratify that. And then when I tell them the child support obligation as a result of that, then at that point they say, oh, no, that's no longer in my child's best interest. Mm-hmm. Well, I want to know that, because my focus is less on what are you paying in child support and more on what's best for this child. So while that wasn't their intent to reveal that their true motives had more to do with money than with caring for their child, now I know that, so I can make a better best interest determination as a result of where the priorities are with that parent. So while it's, and I understand that it has nothing to do with what we're trying to accomplish here today, it does assist the court in figuring out what's best for the child. So I guess my roundabout way of saying is there's value to the fact that it didn't work for me. But I don't know that I can quantify that in a formula or to build in deviation factors into a formula. But if that is true parental motivation, I'm happy that I know that rather than not know it.
This is Bridget Robb, for the record. One of the things I think we've been talking about is the presumptive cap, the presumptive max. We're the only ones who do it. And it's my recollection, although it's deep, dark in the recesses of my memory that that was a legislative compromise. Child support was an issue, and one of the things that got that passed was the legislative cap. We can go back and look at that now. We see how it is inequitable, and while we have cases that say you can actually deviate upward for standard of living, I don't know that that happens very often. And so that is certainly something that this committee can look at, doing away with the cap or finding a way to make that cap more equitable.
Kim Surratt, some of the historical data that was fed to me through this process was that, one, we did the adjusting presumptive maximums on a yearly basis with the illusion that it was a form of doing our guideline review to comply with the feds. Which obviously did not work in our favor at the end of the day because then we had no child support change other than those minor adjustments by the Supreme Court adjusting those caps on a yearly basis, and that's all we got out of it. It took Susan Hallahan, who really spearheaded a lot of this, a lot of fighting to demonstrate that we really needed to have a guideline review and really pushing for it. So and I also think that true upper cap amount between that, and I was not around for that, but I was around for when we added in all of the, when they started messing around with the deviation factors, it just was picked out of the air, all of it. None of it was a whole lot of thought and process put into it. Our original formula system, though, was based off of Wisconsin. And Wisconsin has now, they were one of the ones that hadn't been changing like we hadn't been, but they have now. And so I think it demonstrates, I haven't personally really looked into what Wisconsin is. We did that a little bit during the initial steps. One of our committee members did the research for us, if I remember right, but I don't remember what the formula was. But just trying to add some of that historical flair there.
Karen Cliff from the Clark County DA's office. My boss actually is from Wisconsin. He's provided me so very kindly with their model. So I have that book back at my office. At the time, there were 3 states, Wisconsin, Nevada, and New York, that used the percentage model that we are currently using. It seems that I'm sort of hearing more often than not the need for consistency. And I'm wondering if we can find that consistency in just sort of reevaluating the presumptive max, how we want to approach deviations and health insurance costs, perhaps without necessarily changing the guideline model we're currently using, the percentage model. My fear is with the income share model is when you introduce another party's income, you introduce the various deviations that they may have, suddenly things get more complicated because you have so many more facts at issue. When we remove the presumptive max or take a look at that, it's going to provide so much clarity just in terms of cap versus deviate. We have a case right now out of the Court of Appeals, and it's provided some direction. It's unpublished, but still we look at that and we look at cap versus deviate versus cap. And once you start removing the max or looking at it, I think we might find clarity organically just by looking at some of these other issues. That's it.
Madam Chair, Deputy Attorney General Ryan Sunga, just for open meeting purposes, I just want to clarify for the record, what part of the agenda this discussion pertains to? I know we had our motion that passed on agenda item number 4, and then after that, then that's when we moved into this discussion here, and I just wanted, for the record, to be clear which part of the agenda that we're talking about now. And you can take things out of order, you can combine items, and it sort of seems to me to fall under number 7 or a combination of 6 and 7?
Yes, I'd agree. I was going to say 7 because I had made a comment about, after we made the motion on number 4, I made a comment about, so what is the, for the next meeting, what are we going to start on as our agenda item? Or what are we going to put in the agenda? And the comments flew around about, do we do it based on number 2 out of that exhibit? Do we base it on
Right.
number 3? What's going to be our first agenda item? And that's where we went with this to, and how are we going to accomplish that in our next agenda? Whether we were going to bring research back, that's where the discussion went with that. But thank you.
Okay, so
Yes.
number 7 exclusively then is what this
Number
is.
7.
Okay.
Discuss and approve ideas for future agenda items. Specifically, the next agenda, the next meeting that we have. We didn't we skipped over future meeting dates, which probably we should always do at the end anyways.
Okay,
Okay.
thank you.
So we had a lot of lively comments on that. Yes, Ms. Murray? Okay, so we have the building until 4:30. Okay. We had some really good discussion going, and I think, based on our discussion and me making the comment about setting our agenda item for next time, I think, Mr. Stanford, you suggested number 2, correct?
I believe I
Recommendation.
said number 3, but 2 and 3, I think, are very tied together as to determining whether or not our current system is the right one and whether we should adjust that system is, I think, both numbers 2 and 3.
Do we have a motion or consensus that for the next meeting, we will specifically put on the agenda recommendations number 2 and 3?
This is Bridget Robb for the record. So moved.
I'll second it.
All in favor? Anybody opposed? Motion passes. To specifically put on the record, these were the recommendations number 2 and 3 of Exhibit 44 from the Guideline Review. Number 2 is review the premise and basis of Nevada Child Support Guidelines model. The why is this provides a foundation for other policy decisions. The how is review the premise and basis of the Nevada Child Support Guidelines and other state guidelines in Section 2. Identify and review supplemental information if appropriate. Number 3 was determine whether the base guideline percentages/formula should be changed. The why was the base guidelines percentages/formula should reflect the premise and basis of the Nevada Guidelines model. The how was review the economic evidence on child rearing expenditures in this report in sections 2, 3, and 4, and new studies of child rearing expenditures as they become available. Do we want in the next meeting to add any other agenda items for consideration at the next meeting? Yes.
Keith Pickard for the record. I wonder if in conjunction with 2 and 3, and so this is actually a question, Ms. Murray, if it would be possible to obtain maybe some speakers, some brief presentations on the other programs that we've seen here, maybe one from, someone who can speak to the Utah model, someone who can speak to the other models that are presented here so that we can get some context. Is that even possible?
Are you looking for Nova Murray for the record, are you looking for somebody from those programs to speak to us, or are you thinking that somebody can go out and do the research and come back and speak to what they found?
Yes, either or. I just, somebody that, Keith Pickard for the record, somebody that understands them and can speak to the strengths and weaknesses of each, and we may end up being able to cobble together a hybrid out of the strengths. I was just looking, for example, at the Wisconsin calculating tools, and it appears that they have stayed with the percentage of income model, assuming these are still accurate, though it comes from the Wisconsin government website. And so it may be that in their changes, they've kept that, but they've brought in other It appears that they brought in some other things. They've got the multiplier that was spoken of in the materials. They also look at the other things that we need to talk about, which are split placements and shared placements, and figure that in. But my thought was just have somebody that understands these, whether it's from your office or a practitioner out in the marketplace, someone who can come and give us some context for each of these so that we're not just making assumptions.
Nova Murray for the record. When is our next meeting? I would assume we need some time. I don't have anybody at my fingertips. I mean, I know we can call the other agencies. We can see who's out there. We can see who wants to get involved. It would be easier to get to the program of the other state and have them speak to us. I don't know if they're going to speak to us about your interest per se because you come from the other side of the world. They might be very knowledgeable in my interest because that's where my connections would be. So we can ask and we can see what they have available. We can do some of the research ourselves depending on time, just looking in, making some phone calls, getting some basics. I can't really commit to it, but I could start pushing out there to see what we can find out.
Ms. Murray, if we do go this direction, my preference would be that, like you said, we seek the guidance of some of the states that are performing very well, both insight from the Child Support Office, whether that would be a deputy or otherwise, or the director, and also someone from the private bar in that same county or state to sort of give us that perspective. It would be really, really great if we could talk to a state that went from a percentage to an income share model versus a state that has always been an income share model and knows sort of no other way. In terms of Wisconsin, as you know, my direct boss is Jeff Wattoon, and he's from Wisconsin. He was their previous head honcho. So I'm fairly certain maybe in terms of Wisconsin, but again, they're a percentage model similar to us in New York. So I'll defer to you in terms of what state's high performing and what state we can get contact with. Thank you.
Ryan, I wanted to ask you, if we bring in a guest speaker like that, what's the proper way for us to deal with that through this process?
Deputy Attorney General Ryan Songa, yeah, you could put an agenda item on, not an action item, but you can just say report of. And say if you bring in a guest speaker, or even if that report is from Ms. Murray, you can say report of Ms. Murray on the other states that you're talking about here. You can do it any way you want it.
And another question back at you. If I understand it correctly, if we want to take any action, we have to decide this meeting for next meeting so that it's on the agenda. Is that a fair statement?
Yes.
Okay. Then to answer your question, I think it would probably be appropriate that we deal with, or at least put on the agenda that we're going to discuss for possible action, number 5, which deals with the presumptive maximum, and number 7, dealing with the appropriateness of the minimum, because I think that those two are probably need to be part of the discussion of how we're moving forward. So that would be my suggestion. If we're looking to 7 is
7 subsumes 6.
Well, that's the 6. I think 6 probably needs to be on there as well, because that's part and parcel of the calculations that we're trying to make if we're making changes to what we're doing. To what Nevada is currently doing, not what we're doing.
Nova Murray for the record. I think that you could put that on there, and if we can't get to all of it, we'll push it out.
Then I'll go ahead and move that what I said before is what I'd like to do. How's that?
Second.
No.
It's on the record. It's all on there. Then I move that we put on the agenda for discussion and possible action from Exhibit 44, numbers 5, 6, and 7, dealing with maximum, minimum, and the self-support reserve.
Second.
All in favor?
Aye.
Anybody opposed? Motion passes. Do I need to read them onto the record like I did before, Ryan? No. Okay, because I know the guideline review is.
Yeah, I think if a person, a third party that wasn't here is looking at the record, they could see that previously you made reference to all of them, and therefore they could reasonably piece it together. But if you want to be really, really safe, you could read it in. It wouldn't bother me either way.
Okay, how about I at least read the title lines and not the why and how? So number 5 was eliminate the presumptive maximum amounts and replace them with a formula and provision consistent with economic theory and the economic data on child rearing expenditures. Number 6 was develop a self-support reserve or low-income adjustment like those used by other states. And number 7 was review the appropriateness of the minimum order and make changes if necessary. So based on the 2 motions we had, I believe next agenda will include recommendations number 2, 3, 5, 6, and 7. Okay.
Just to be clear, those are 2 different agenda items for this coming up agenda, right? The first motion would cover 2, 3, 4 on one agenda item, and then discussion and possible action on the next motion, which would be 5, 6, and 7. Those would be stated separately on the agenda, I'm assuming? 2 and 3? Okay.
Just 2 and 3. I don't believe 4 was made part of the motion.
Okay.
And I do...
But you do want 2 separate agenda items, though, action items?
I would say...
Because we may not get to 5, 6, and 7.
Yeah, we may not get to 5, 6, and 7. So yes, I agree with that.
Okay. 2 separate action items on the next agenda then. Correct?
Can I make a recommendation? I think 2 and 3 would be one agenda item. Number 5 would be another agenda item. And 6 and 7 really are the same thing. They're both about minimum orders. And 6 and 7 could be a third agenda item. And if we don't get to that one, that would seem to make more sense to me. Are we okay with that? Do we have a motion to, well, I guess I can make a motion for that.
Just a motion for clarification.
Motion for clarification. We have a second?
Second.
Second.
All in favor? Aye. Anyone opposed? Motion passes. Now that I said that, I want to write a note to myself. So 2 and 3, 5, and then 6 and 7 is separate. Okay. All right. With that, we have to discuss agenda item number 5 about determining a process to set up future meeting dates. And we specifically, because we knew we were going to be kind of digging into this for this meeting, we all came together, we flew so that we're in one meeting spot. Do we want to do that on the next meeting?
Do that on legislative commission?
No. As long as technology is working, it's not so bad when it can focus in on each person. So if we're okay staying north and south for the next meeting, I think I need somebody to verbally address that as a motion.
Suppose I made the motion last time that we all meet down here, so I'll make the motion that we don't do that again.
Second.
All in favor?
Aye.
Anyone opposed? Yeah, I don't know about ever again.
Yeah.
All right, so next time we will hold it in Carson and in Las Vegas. And what do we think about a date?
Nova Marie, for the record, we do have the ability to do the same thing we did last time. We push it out to you, throw the dates out, and get the maximum amount of people we can get on those dates. We can do that. We can just repeat the process.
I would state that's a good process. We need a little bit of guidance, I think, on what we think, are we looking at a few weeks? Are we looking at, a month would be too much. We have way too much work, in my opinion, to accomplish, to push it out that far. So if we can look at the next, within about 2 weeks, would it be sufficient for everybody to assess what our agenda items are and come to some opinions and come to the next meeting with some opinions?
Madam Chair, if I may, Ms. Murray's concern was time to maybe get that presentation put together. Since we're using electronic means, we might be able to do that remotely as well. Do you think you could arrange something in 2 weeks, or is that too aggressive?
Nova Marie, for the record, that is extremely aggressive.
I could throw out there that I bet we could get Jeff to come within 2 weeks. Am I right, Miss Cliff, to at least talk about Wisconsin? I'm just throwing Jeff under the bus.
Yes, but sorry, Karen Cliff from the Clark County DA's office. But again, their model is similar to Nevada's. If you really want some different perspective on a shared income model, we may need to reach out to some other states. But I'm sure he would make himself available.
Ms. Cliff, do you know if he's aware of the newest changes in Wisconsin, the modifications they made?
I don't know if he's aware, but I know that his contacts are substantial, and I'm sure he can obtain any change for our purposes.
I would propose that we at least tentatively place a report of Mr. Watoon on the agenda, and obviously if he can't make it, there's not much we can do about that, and that agenda item will be dead at that point, right, if he can't. So I say we propose that for an agenda item. And then can we put a tentative holding spot on the agenda for a report from other states? Okay. Then I propose we also put on the agenda report of, what do we call it?
A state that's gone from income.
State report
Of alternative models.
of alternative models. There we go.
This is Joe Sanford. I'll second that.
All in favor? Aye. Anyone opposed? Motion passes. And we're going to look at potentially within at the 2 week mark, correct? So the proposal is, the hope is that within 2 weeks, but we will have the state put out the email that we did this last time, looking for the date in which we can get a majority of members to appear. And we will go with the date that accomplishes that. If 2 weeks does not work, my proposal would be we look 2 to 3 weeks, but we don't look at under 2 weeks, because I think that would probably be far too aggressive for all of us to come back to the table. Do we have agreement on that?
Yes, I just wanted to add, just for Ms. Murray, in terms of obtaining a speaker, there are some states noted that have changed their models to include District of Columbia, Georgia, Massachusetts, Minnesota, and Tennessee that have changed their guideline models to the shared income model. So if we could obtain someone from any one of those states, that would be really beneficial.
This is Joe Sanford for the record. I just want to clarify is if none of those speakers are available within 2 weeks, do we still want to have a meeting, or do we want to have Ms. Murray wait until she actually has one of those speakers and then set a date that will work for them? Just 'cause I'm not sure that if we want to have an action item to make a determination before we've had that presentation.
Yeah, I think I would be, as long as it's my personal opinion, and everybody needs to give input, that within 2 to 3 weeks, we need to have another meeting. If we go longer than that, I think we're putting ourselves at risk. We're going to start feeling the pressure of all this stuff piling up on us, and just be too tight of a timeline. But I welcome input on that.
Nova Marie, for the record, we do need the meeting, and I will push really hard to have presentations from those states. And if I don't have many of them, I will at least have one of each. I'll work really hard to get the one that changed, and I'll work really hard to get something from a high-performing state. And I will work to try to get somebody from the private bar, and I will work to try to get somebody from the 4D program.
So we have our meeting date. We have what place it will. Well, we don't have a date. We're gonna send an email out. It'll be between 2 to 3 weeks. We have our agenda items. I think we have sufficiently satisfied agenda.
Except for number 6, we didn't talk about number 6, but you can.
Well, I was going to say, we have sufficiently satisfied number 5 and number 7. Number 6, we have on our agenda open discussion on guidelines. We kind of did that.
That's what I was thinking. It was sort of part of the same conversation as you had with number 7.
Do we feel a need to table that or place that on the next agenda so that we have the ability to do some continued open discussion on the guidelines?
No, you could, there's a number of things you could do. You could make it clear on the record that discussion, that you folded that discussion into number 7 because you can combine items. Or you could just put on the record that you're choosing to not take any action on that item as the chair. You can do that as well.
All right, I would state for the record that we have chosen to not take any action items on agenda item number 6. Okay, I think unless we need to go back to any of these agenda items, that we have met each of them and we are potentially ready for public comment. I just want to make sure we have a consensus on the agenda because that's one of the biggest items for us for the next meeting and that we're set on that. I had also, I think if we do this each meeting for the next meeting, we're okay versus last meeting we had kind of made a comment that we would produce our report by, not kind of, we did make a statement that we would replace our report or have our report done by April, was it April 1st? Yeah, April 1st of 2018. So I'm just kind of throwing that out there in consideration of our ongoing tactics of knocking out these agenda items and getting the work done. So I think with us attacking 5 different recommendations all in one meeting, it's going to be a busy meeting. Okay. Ms. Murray?
For the record, Nova Murray. It would also say if I'm going to have 4D participation as a presenter, they have a big conference and they're all gone. I think they're in Alaska 2 weeks from now. Just as an FYI.
Kathleen Baker from the District Attorney's Office in Washoe County. The conference is the 24th through the 28th. So if it's in 2 weeks from today, that's the 22nd. People should still be around.
So we're pretty solidly looking at the 3-week mark at this point. I think we're okay with that, right? I think based on the intense conversation we had, not intense, but the great conversation we had, we may all have, with each of these recommendations, an eye on what we want to reread within the materials that we were given anyways, and do some soul searching on those anyways, so. Right. Okay.
Madam Chair,
yes.
may I ask a question of council?
Mm-hmm.
Some of us are going to have difficulty making one or the other of these dates. Are proxies acceptable?
Yes, in fact, I think somebody already did it.
All right.
First meeting. Member Fumal were there, yeah.
Well, you had someone appear in your stead.
Ozzy Fumo for the record. Yes, I had Tyrone Thompson here. I was out of town.
I'm asking.
As long as we have a quorum, we can still do business.
All right, thank you.
In speaking about the future meeting dates, the notice is placed on DWSS's website, and we had discussed at the last meeting methods of getting that notice out there. We're going to have to kind of now that we're going to do some specific agenda items with very specific details, we need to crank up what our goal was in the last meeting on that notice part of it, and getting the information out there the way we discussed. So just comment for the committee members about getting that notice out there.
Nova Murray, for the record. Should that be a agenda item, since something, I'm assuming something has to be created to do that? This is not really explanatory when you see it on the website or when you see it in an office, so unless somebody has a background that says this meeting is really looking at changing the way we calculate child support, guidelines don't really mean anything to the normal human. If it had a cover lettery kind of something so that everybody's staff isn't sitting in the lobby recruiting people, they could say, oh, here. They could hand it to them, and it's a nice recruitment. This isn't perfect. Maybe we need an agenda item that addresses how to get them outside of just posting this piece of paper, because this clearly isn't working.
I could be wrong, but our agenda item was determine process to set up future meeting dates, and I think under process, notice is obviously part of setting up those meeting dates, because notice is critical to this entire to the entire procedure. And I know that we all stated a great concern that we get some public participation and get notice out to the public so that we can have the public participate in this. So am I wrong when I say process can cover that?
Yeah, I think so. And
okay.
One, I can, Ms. Murray, I can help you craft more specific agenda items for the upcoming meeting. And secondly, you can always do more than what the open meeting law requires. You just can't do less. So if there's better notice that you have in mind that you want to get out to the public, you can do that. We just can't do less than what the law requires.
So I know there's fathers' rights groups, and then there's mothers' rights groups, and there's all sorts of groups out there. Is there any way to get them, and again, it's kind of, you don't want to have a 4-hour circus of people who are unhappy with what happened in the divorce case, but I think some of that feedback kind of across the spectrum would probably be really helpful to us to understand how the impacts are actually affecting families.
Kim Surratt, for the record. There are, and we at the last meeting discussed different ways we wanted to get the information out. I think the reality of it is that as commission members, we almost need to divvy up and make sure that happens, because we can't rely necessarily on our state employees to have access to all of those. Like a couple of the listservs I mentioned last time are just listservs that I'm a member of, so that's fine. Or there's 3 of us that are 4 of us, that are actual members of that listserv. So somebody just kind of has to take on the duty and obligation of getting it out to these places we've talked about, because it doesn't, I think the concern is it doesn't just, or my concern is it doesn't just happen. There's not a magic gnome getting out there and doing that for us unless we can dictate to the state to do that for certain things, but I don't know how appropriate that is.
Dawn Throne, well, partly we want to get to the people who need this information, like who use it in family court. So I was thinking, can we post this at family court? Can we post it at the self-help center? In Clark County, we have a separate child support office. That would be an appropriate place to post it too, if that's possible.
Again, it's the comment of, it's probably possible, but then somebody has to go do it.
Nova Murray, for the record, I think the first thing I need is a medium, because this doesn't work. So we need to create a completely separate document that is more public-friendly and include that meetings will be created and how to find them in the future. So more of a how-to, what you want to talk about, the calculation, and take it down to a 6th grade level and include this. And are we allowed to just create something? Because I could hand it out to all of you, and you could put it on all your listservs if I'm able, outside of this group, to say, I'm just going to go do that, I don't need your approval, and I'm just going to start I don't know the answer. I don't know what kind of a restriction I'm under or not, but we do have outreach folks in like a PIO capacity that could do something like a flyer that looked better than something I would create, and they understand what to do for the public.
That's a good question, and I think to be safe, you would need an action item. You could delegate it to somebody, and you could specify what medium you're going to use, what form you're going to use. Unfortunately, it's not on our agenda today, so, but the chairperson could, for the next meeting, get it on the next agenda for a discussion and possible action on the outlet that you're going to use to advertise this committee's work.
So let me make sure I understand. You're telling us that we're limited in how we can announce an open meeting?
No. I think the safest way is to always do it through an agenda item so everybody knows. But I don't think notice over and above what the open meeting law requires actually requires that.
Okay, then that's kind of where I'm at. So if I was going to make a suggestion, it would be that if we can get somebody to create the 6th grade notice and you get it to all of us, I can think of probably 2 or 3 outlets, one being my court webpage and another being my PIO to get it dispersed wherever she does that kind of stuff. And if we all have it and we've got 2 or 3 outlets, then I think we're substantially better off than we are if none of us do it. So I don't know if that's and I know it's not on for an agenda item, but that would be my suggestion anyway, as far as notice is concerned, as long as we're not violating anything by putting extra notice beyond what we're required to put.
Yeah, Keith Pickard for the record. I would just want to follow on to that. I think that I understand what Ms. Murray is saying in terms of, the form isn't working, but I don't know that we need to change the form. And to the extent that the legislature does it and we end up packing the room sometimes, it works when people are interested. But I don't think we need an action item to ask individuals to send out a notice in whatever form they choose, in addition to the formal notice. I think that that's probably good practice that you send it out, that we get it on the listserv, that we use the department's resources, but these are all in excess of the official notice. The official notice is all we need to do, and that's what I would suggest we do, and then, everybody go at it.
Yeah, you're never going to get in trouble for giving too much notice.
So without an action item, we're all going to work our butts off on it. It's just a generic statement of give notice, lots of notice. And if you have access to listservs, whatever it may be, once it comes out, we'll just all attack it. The last agenda item we have is number 8. It's public comment. Do we have anyone in Carson City that would like to give public comment? No? Anybody here in Las Vegas that would like to give public comment? Seeing none, then do we have a motion for adjournment?
So moved.
Second. All in favor?
Aye.
Anyone opposed? Motion passes.